On March 25th, a Sixth Circuit Court panel ruled that Donald Trump's bump stock ban was unconstitutional. But as is often the case when courts rule against government infringements on the right to keep and bear arms, it was a Pyrrhic victory because the majority danced around the core of the issue, that any and all gun statutes on all levels of government are unconstitutional infringements on the right to keep and bear arms. Hi everyone, I'm Gardner Goldsmith for MRC-TV. You know, as even someone with a weak grasp of the Constitution might have expected, a three-judge panel of the Sixth Circuit Court of Appeals on March 25th reversed a district court ruling in favor of President Trump's 2018 executive order banning so-called bump stocks. This 2-1 ruling against the ban came in the case of Gun Owners of America Incorporated et al. V. Garland et al. And it represents a huge victory for plaintiff Gun Owners of America. But it reveals something very troubling. The judges comprising the majority focused far too much on legalese and statutory detail while overlooking the obvious fundamental rights and constitutional rules that should drive their jurisprudence. In other words, even though this is a ruling that helps bump stock owners in the short term, it does nothing to support the fundamental right to keep and bear arms or challenge the faulty, dangerous idea that politicians can attack that right if they merely pass a statute. As Jordan Davidson writes for The Federalist, the Trump administration first issued the regulation in 2018, approximately a year after a shooter used bump stocks on his rifles to carry out a mass shooting at a country music festival in Las Vegas that left 58 people dead and hundreds injured. Bump stocks, federal officials argued, modified semi-automatic rifles enough to be classified as machine guns, which U.S. civilians are prohibited from owning without special federal permission, and required quick action from the Department of Justice to make it a felony offense to own or use one. Those who had bump stocks at the time the rule was issued were ordered to destroy or surrender the gun modifiers to ATF. To be more specific, Trump's executive order charged the ATF to consider a bump stock to be a machine gun, thus making it illegal to own without special federal permission, per the blatantly unconstitutional 1934 National Firearms Act. And as one might guess, the judges of the Sixth Circuit spend a lot of time and a lot of page space focusing on the semantics of whether bump stocks are machine guns and whether the regulatory agency of the ATF can ban them and threaten legal punishment without first having a new criminal statute written by Congress. Amazingly, after many pages explaining their tiresome research into the obvious, the majority on the Sixth Circuit panel found that a bump stock is not a machine gun. Quote, in sum, based on the text and context of subsection 8545B, and further supported by the Supreme Court's interpretation in Staples, we conclude that the phrase, quote, the single function of the trigger, end quote, refers to the mechanical process of the trigger, not the shooter's pulling of the trigger. Consequently, a bump stock cannot be classified as a machine gun under subsection 5845B.
Right.
Well, thank goodness for their genius. And they also cited legal precedents informing them that a regulatory agency simply can't expand its purview and apply criminal penalties to transgressions which were not originally part of an agency's statutory charge. In part, they wrote, quote, even when an agency implements the will of the public correctly, that determination may still violate the separation of powers. Plato would be proud. These black-robed oligarchs. It's incredible. And these are the good guys, wink, wink. But that overlooks a much more important point. Rights are not supposed to be subject to the will of the public working through the polis. That's why they're called rights. And that's why the Second Amendment explicitly prohibits any infringement on the right to keep and bear arms. Prohibiting something that can make one's firearm function as one wishes is a clear infringement of one's right to self-defense with a firearm, just as banning handguns would be or banning certain kinds of rounds would be. And the court's lack of perspicacity, the judge's evident laziness to get to the root of the matter is extremely vexing. Indeed, if the majority of the court are so concerned about the separation of powers, as they call it, that of course is laid out in the Constitution, then why don't they consider the rest of the Constitution and open their eyes to the fact that the ATF and all federal, state, and local statutes that have attacked the right to keep and bear arms are clearly, obviously infringements on the right to keep and bear arms that is supposedly protected by the U.S. Constitution's Second Amendment. How much more obvious could it be that the judges are picking and choosing which portions of the Constitution they want to stress as untouchable? In fact, the separation of powers isn't even a right. It's just a functional concept that doesn't go as deep as the inborn human right of self-defense. Now, to give the majority of the Sixth Circuit some credit, they did rule on two aspects of the case that offer good reminders of at least a couple constitutional points. As the Federalist Davidson notes, quote, "The newest ruling out of the Sixth Circuit, however, grants the movement, Gun Owners of America, a preliminary injunction against the order, affirming the group's concerns that the federal regulation violated, quote, the Administrative Procedures Act, the Fifth Amendment's taking clause, and the 14th Amendment's right to due process," end quote. The latter two are very important and valid points that many who argued against Donald Trump's ban made when he signed it in 2018. Now that Donald Trump is out of office and Joe Biden is in, the new administration likely will appeal this all the way to the Supreme Court. And it's likely that the majority in the court will rule as narrowly as the Sixth Circuit, not doing what is actually proper, not abiding by their oaths to protect and defend the U.S. Constitution, and not striking down the 1934 National Firearms Act as they should. Meanwhile, more politicians will propose more statutes to crush the right of self-defense, and more law students will learn about precedents like this in the grand tradition of lawyers and politicians who, on the whole, don't show a moment's care about the fundamental rights of mankind. Thanks so much for watching, everybody. Hey, if you're on YouTube, hit like, subscribe, make sure you share these with friends if you get the opportunity. See us over on Rumble, see us in Parler, see us in Facebook. We're on Twitter, we're on TikTok, we're on Instagram. I'm on Gab, it's at Gardner Goldsmith on Gab, and I'm on Twitter at Gard Goldsmith. And of course, if you get the opportunity, please go to MRCTV.org. That is the focus for everybody who does the work for MRC-TV. What a great team. Thanks so much, everyone. For MRC-TV, I'm Gardner Goldsmith.